hear ye, hear ye. All persons having anything to do before the honorable justices of the Supreme Judicial Court, now sitting in Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. You may be seated.
Good morning. SJC-11723, Commonwealth v. Donovan, Smith.
Mr. Safar, before we start, I gather you're having a tough morning with migraines. If you wish to sit, or if you wish to take a break, we will give you that, and it will not cost you time.
Thank you, Chief Justice Gantz.
With that, you may proceed.
May it please the Court, Aziz Safar on behalf of Donovan Smith. I'd like to begin with the deceptive interrogation issue. Shortly after Mr. Smith...
Can I ask you a question before we begin? I couldn't find a transcript of the interrogation. Does one exist?
No, one does not exist, and I had moved for transfer of the exhibits that were before Judge
No,
Kent
I
Walker.
know that, but there's no transcript of the interrogation, so we
don't-
have to watch the video in order to be able to see what happened.
That's right, Justice, yes.
Okay.
Shortly after Mr. Smith waived his rights, the interrogation devolved into the detectives using false evidence to accuse Mr. Smith.
Now, the judge, the motion judge basically said that much of that evidence was in fact, it may have been a little bit of sleight of hand, but it was essentially there was more of it that was true than was false.
I completely disagree, Your Honor.
Okay.
They told him that they recovered his glasses with his DNA on them from a co-venturer's house, that his fingerprints were found in the victim's car, and Judge Kenton Walker did credit that as being false, but also that the defendant and his brother were captured on video at the scene, and that there was video footage showing the defendant in the car with the victim prior to the shooting and then fleeing from the scene after the shooting. Now, at the suppression hearing, Detective Tarquini testified that, based on the information he received, he was convinced that the suspect in the video was Mr. Smith. However, he conceded that he couldn't make out any of the facial features. And I suggest when the challenge is on presenting this evidence as indisputable, that you can't...
Wait a second. Wait, hold on. They had interviewed the co-conspirators here who said, yeah, he went with a gun to do this robbery, and then you have him of someone looking very much like him fleeing.
Well, respect
On film. And so the police officer saying, we have you on film, I don't think is that big of a reach.
But when the question is, was his will overborne, I don't think we could substitute the detective's subjective thoughts for what he led Mr. Smith to believe that this video, in fact, indisputably depicted him. And that's what was going on in Mr. Smith's mind.
It might be one thing if there was no video, but the fact that the video wasn't clear, but combined with the other information the police had, I mean, this is hardly making up a video that never existed.
But it's the way the message was conveyed to the defendant in the totality assessment. He never told him that the information came from these interested witnesses. In fact, they were the primary suspects before they pointed the finger to my client.
Can I just ask you, though, didn't the police tell the defendant that the video showed him and his brother, and they also showed him inside the car? And that's not anything that the video showed.
That's absolutely right, Justice Lang. It didn't show that.
Were fingerprints ever found in the car of your client?
They were not. And there was a totality of deception. And then at one point...
Well, he was in the video. What was he in the video doing? What was the person in the video doing?
The person in the video was in the car, talking in the car.
Okay.
But it doesn't mean it was him.
I understand that. It was a person in the car, what, seconds before the shooting of the other person in the car?
Yes.
Okay. And does the video also show him leaving the scene?
It shows somebody leaving the scene.
Okay.
But that description could fit a large portion of the population.
It could, but his co-conspirators have already been interviewed by the police and said he was the guy that was sent to do the robbery.
But they have an axe to grind, and that's true if they're believed. And the detective never says that the source of this information. Now he doesn't have to tell them that.
I mean,
but
so
when
the
you're-
police
when
are
you're-
supposed to say, we have your, people who have said you did this in conjunction with them. You came back to
Not
their
at all.
apartment, but we're not sure we believe them, and they have an axe to grind.
Not at all. He doesn't have to tell them that. But when you're combining this evidence in conjunction with lies, and you're presenting everything as indisputable, and we're looking at an assessment where has this young defendant's will been overborne, I think that's a factor to consider.
Can I ask you this?
Can I ask you whether or not the defendant made any inculpatory statements before these alleged misrepresentations were made to him? Everything that he said that you're worried about happened after these.
That's the other issue. I mean, there was an issue that wasn't raised below, and I'll get to that. But I just wanted to touch on this. There was also this minimization that was going on. Detective Tarquini suggests to the defendant that he may not receive a life sentence. He tells him, "You were in the car. Did she pull out a knife, a stick, or a gun?" And goes on to say, "Did she do something? Because that makes a huge difference." Then at another point, he says, "There's one thing to defend yourself. It's another thing to do it just because." And these statements weren't made to elicit some insipid response on self-defense. They were more, if you tell us you're in the car, we'll go easy on you. I mean, that's the tenor. That's the meaning of this whole thing.
We've had a number of cases with false statements by police and minimization by police, and in most of them, we've upheld the voluntariness of the confession. What distinguishes those few cases where we've said it's involuntary from the ones where we've said this is so bad that it is, it's so bad that it's involuntary versus those we've said, yeah, they were false statements, they're minimization, but we still think it was voluntary?
Okay, even if the admissions did not exactly conform to the suggested scenarios, like what happened in DGM Batista, the detectives still led Mr. Smith to believe that he would benefit from a confession. And I know, well, they're telling him you've never been in Walpole, you may not, it's not necessarily true that you'll receive a life sentence. And at one point, one of the detectives even says to him to the effect that, "We have your brother, do the right thing for your brother. Will you look out for him, or will you look out for yourself?" Hanging a family member over his head, a la Charles Monroe's case. But now I'll turn to the point
Who
that...
was his brother?
I'm sorry, Justice Cordy?
Who is the defendant's brother?
Oh, Marcus Young. Marcus Young.
So can you turn to the invocation?
Could I just,
certainly.
before you do that, could I just, I wanted to confirm one thing, which was Marcus Young. They also told the defendant during the interrogation that they had already spoken with the brother. Was that true or was that false?
I believe it was true. He was there in custody at the same time that the defendant was in custody.
They'd arrested both of them at the same time.
That's right, and they were going
interviewing
back
both
and
of them.
forth in the rooms. And you'll have the interrogation video, and you'll see that they were leaving the rooms quite often.
Can I?
They said, "We have your brother." They did have his brother.
They did have his brother, but they're using it as a ploy. He said, "I'm tight with my brother," and they're using it as a ploy to get him to confess. I mean, that's pretty bad.
Can I just ask you, I know I want you to go to the other question, but this is before we get there. If the detective has viewed this video and has for a variety of reasons, has a belief that indeed it is the defendant, are you suggesting that because he can't be 100% sure, he can't say anything about it? He can't say we've got you on video? I mean,
I'm saying in the totality of the circumstances, when they're pushing this evidence in conjunction with lies to portray everything as indisputable. If you look at the tenor of all these things, you know, it's an army of words where the sum of which is, you can't challenge this. It's scientific evidence. It's video evidence. It's clear.
That's like the fingerprints. I get that. I just
Well,
don't-
even with the video, it was portrayed as he doesn't. I mean, he doesn't have to tell him this is the source. He doesn't have to tell him because so and so or the names of the witnesses. But if he's presenting it in conjunction with lies, the whole thing. He's presenting all this evidence to him as indisputable. You can't challenge this, so you have no choice but to confess. You only have to gain because you've already lost. The case is proved against you. But turning to the invocation issue, before he breaks down and admits, Mr. Smith says, "I'm done," to which Tarquini responds, "You're done with what?" A fair question. But then, as clear as day, Mr. Smith says, "I'm done talking. I don't want to talk no more." And that's where the interrogation should have ended.
What followed, assume you are correct, what followed after that?
What followed after that, rather than ending the interrogation,
No,
the
I know that.
detective,
What did he say? What?
detective lures him into continuing to speak.
Right, and what was the evidence when
The
he keeps
detective,
speaking?
lures him in and he says, "You don't want to talk anymore?" And,
No,
and
I'm
the
sorry,
defendant
I'm just
says,
not being-
"Oh, the next line from the defendant?"
Yeah.
Well, there was a question there, so.
Oh, I'm sorry, let me
Sure,
step back.
I'm sorry, Justice
No, it's
Bostic.
my fault. There is this exchange, and let's assume that it was improper. He should have stopped exactly when he did. What I'm trying to find out is, what's the evidence, the inculpatory evidence in terms of statements about this event that followed that?
Okay.
Was there a
But-
lot?
But
Was there a
I think,
little?
I think it's important that I give some context to the dynamics.
Okay.
And when you watch the interrogation video, you'll understand what I'm talking about. So Detective Tarquini says, "You don't want to talk anymore." Defendant responds, "No, cause you all really don't believe me." But then the detective begins using all these words, including falsely describing the strength of the case, while Mr. Smith is sitting with his head down, mostly quiet for the better part of 4 minutes while this conversation's going on. You know, he's kind of, boxed himself in, and you'll see it in the video. And then Detective Tarquini at the end says, "So you know what happened," after which Mr. Smith begins making his admissions. And I know this argument wasn't raised below, but the motion judge should have been alerted to the problem through the interrogation video and through Detective Quidadamo's testimony at the suppression hearing when he said the defendant said he didn't want to talk anymore, but he kept on talking. So it was no mystery. The judge wasn't oblivious to this. It just, nothing ever came of it. These admissions mattered because there was no forensic evidence pointing to the defendant, and the two disinterested witnesses could not identify the defendant as the person they had seen fleeing from the scene.
They described characteristics and the clothing he was wearing, however, and they found
Well,
that clothing.
Well, it depends which version you accept. I mean, one of them said that it was a gray shirt, and one of them said it was a black shirt, but for the most part, yes.
Do we have any description in the record of what the brother looked like, Marcus?
Well, yeah, there's some mention in the record that he was about 6 feet tall.
So a lot taller.
Yes.
A lot taller. What about
Oh.
the build? Anything about the build or how he wore his hair?
Yes, he had like almost like locks, like like curly.
Cornrows?
Yeah, and the defense attorney tried to bring out that the jeans that were found in the house some 6 weeks later, and again, there was no residue found on those. There was no DNA, no forensic
DNA
evidence.
testing done, was there? Because there was no, I mean, it looked like blood on the shirt.
There was
and it
no
looked like
testing
blood
done on
the,
that, and I-
pants, but it turned out not to be that,
That's
right?
exactly, well, the Commonwealth didn't perform testing because they assumed, according to that, because they were washed, in the interim, it was 6 weeks later that they were found. But the defense attorney tried to link the genes to Marcus Young, saying that they were more consistent with Marcus Young's size.
If we could go back to Justice Botsford's question, which essentially is, if you were to prevail on your invocation claim, what evidence came in after the invocation that would be prejudicial to your client? Well, actually, it'd be more than that. It would have to create a substantial miscarriage because it was not raised below,
Okay.
or substantial risk of a miscarriage.
Let me take that in the order you presented it.
Likely.
He had
Substantial
said that-
likelihood of a miscarriage.
I'm
Get
so-
it right.
The admissions that he made were, I was in the car with her. There was an attempt to rob her.
This is all after that invitation.
This is all after that. I was in the car with her. We had attempted to rob her. I did not have a gun. She was fidgeting in her bag, and I left. And then his admission evolves into, as I was leaving, I heard shots. I heard gunshots. And then later on, he says he did change his shirt at Will Madison's apartment. That's at 6 Vernon Street Place, where they recovered the shirt, the black shirt.
And this did not come in until after
That's
the-
right. There
the
was
so-called
no,
invocation.
there was not one iota of anything that resembled an admission prior to this situation where he says, I'm done. I don't want to talk no more. He doesn't want to talk, and there's nothing said before that, and it's after that that all these things begin coming out. And he's sitting there for like 4 minutes. He has his head down. He's almost in a ball.
Now, what do you, I mean, counsel, your sister takes pains to say, well, he didn't say simply, I'm done talking. He went on to say, because you guys really don't believe it. And the view is that changed it from an
No, it was not-
invocation to something different.
I'm sorry for interrupting.
No, that's all.
It's not so much that he continues talking, it's that they continue interrogating him. And he responds. He's feeling it's an exercise in futility at this point. Even he goes into a ball. But before that, yes, he says, cause you all don't really believe me. I mean, there's no need for a question there. I am done talking. I don't want to talk anymore. That's clear. It's done.
And they didn't ask him any more questions after that to try to clarify.
No. Well, he says that you don't want to talk anymore. I mean,
No, those two questions that they asked, basically, he echoed, you don't want to talk, I'm done, you're done, I don't want to talk anymore, you don't want to talk anymore. And after that, there were no clarifying questions.
That's right,
It was
Your
just,
Honor.
everything that was said by the Commonwealth by the police officer afterwards, had to do with interrogation. It had nothing to do with clarifying.
that's right.
So at trial, 3 of his joint venturers all testified that they planned this together, that he had a gun, left the house, came back with the gun, running back, changed his clothes. So that's sort of relevant and direct evidence, correct? They had the film, which was admitted, correct?
That's
the
correct.
videos, which you say don't really necessarily, but that was evidence that the jury had, in
But
addition to the co-conspirator saying, yes, we did this.
But that's if the jury believed their version that the person was who they said it was. That it
Okay,
was the
and that,
defendant.
well, I mean, they can make their own judgment. They could see the video, that's why it was
Well,
offered.
here's the problem. The admissions lent credibility to these witnesses whose testimony was already suspect because of the deals they were receiving.
Yeah,
Their testimony was inconsistent. One said Mr. Smith left the house on his own to commit the robbery. The other one said no. Will Madison said he joined with Marcus Young. They were all at the scene.
They followed him, that's what they said. They followed him.
Well, they were at the scene, but it's still, I mean, maybe it's not a material inconsistency, but it's a consistency nonetheless to show that these witnesses were looking to curry favor. They're testifying under a deal. And then when you inject the admissions into that calculus, now Mr. Smith's admissions lent credibility.
He admitted he was there, denied he had a gun, and denied he shot this person. He admitted he was there. at the car for a few minutes. And let me ask you one other thing. Did they also, he made some statements after the police ended the interrogation. He was in the room alone, correct?
Yes.
And he started talking to himself.
Right. Yeah, what happened?
Those would be admissible in any event. They weren't the product of interrogation.
Well, you know, that's kind of different from what happened in the Meehan case, because these weren't blurted out to a particular audience or to a person.
He just
This
said it
was
out
kind
loud.
of like, this was an amplification of his own thoughts without any immediate context. And trial counsel below, at the motion hearing and in objecting to have this not come in as an admission, said these are very ambiguous. The portion that is inculpatory, we don't know who the you is referencing. You know,
Because it sounds like it was, why did you shoot her? I didn't shoot her. I didn't even shoot her. You can't shoot that bitch.
well, I actually heard it again 2 days ago, and and you'll hear this, and I listened very carefully. He says, "Why'd you shoot her? Why'd you shoot the bitch? I didn't shoot her. I can't even effing shoot her." But the thing is that the Commonwealth literally and figuratively blew this statement out of proportion. It's not clear
I
to
thought the
whom-
jury saw the statement.
I'm sorry, Justice
Didn't the
Lewis?
jury see this?
They saw this. It shouldn't. That's the point. It shouldn't come in. I mean, because
You mean that you shouldn't have had the witness shouldn't have testified to what he said? Is that what you mean?
well, both. I mean, Quidadamo was testifying to what he had heard, and the judge said that was okay. The objection on having it come in as an admission was sustained, but I mean, you need the media in order for the witness to testify to it. So
But I'm not clear on one thing. I know your time is up, but getting back to the invocation, is it your position that it doesn't mean anything that the defendant said, because you guys don't believe me, as if that was
Well,
an
that's-
invitation to be more favorably disposed toward the statements that he was giving? And let's talk some more, so maybe I can convince you.
that's like the Hearns case. You know, attaching a condition where you've already made clear your intention to cut off questioning. And you know, the Commonwealth points out in its brief that, you know, there was this pattern going on. And I say he's entitled to avail himself of the right to stop at any time, so long as it's clear. And it was clear here. It shouldn't have gone any further. And with that, if there are no further questions, I'll rest on my brief.
All right,
Thank you, counsel.
Good morning. May it please the Court, Susan Oftring on behalf of the Commonwealth. With the Court's indulgence, I'd like to first briefly address the first issue that was discussed this morning with the defendant's claim that there was police coercion. The totality of the circumstances, and when you see the interrogation, there was no coercion whatsoever, and the motion judge ruled correctly. As to those two particular pieces of evidence that, as my brother argued, Detective Tacchini did acknowledge about the fingerprints being found in the victim's car and the DNA found on glasses left at Will Madison's apartment, it's significant in the interrogation that the defendant was not swayed. He didn't believe it. He said about the fingerprints, "I don't believe it." That's, I think, 2 or 3 times, "I don't believe it." When they were asking him about his glasses and where he got them and where they knew, and that they had found his glasses at Will Madison's apartment, he expressed skepticism at that and said, just because they have my DNA on them doesn't mean they're my glasses. So throughout the interview, when the police would express or inform the defendant of the evidence, he was able to determine what the tactics were for what they were. And oftentimes, and again, if you look at the interrogation tape, you'll see him nod his head affirmatively. I want to say 75% of it he understood, okay, and he went along with the interview, even when some of the most incriminating things were being mentioned, such as we have you on video, we see you. He nods his head and says, Every time that
He
the
also said
police-
he'd like to see that.
Excuse me?
He's also saying he'd like to see it, and they, of course,
Right, and they said it would eventually be made available. And while we're talking about the video, if I could just for a few minutes explain what it is on the video. The house that captured these videos had cameras at all different angles. So when the victim's car first entered into one of the camera shots on Fairfax Road, the police and the jury were able to see the victim get out of the driver's seat, some figure, and that's probably the worst picture you can see because it's a little bit further away. You see a figure, there's a muffled conversation, you hear two doors slam, and now there's two people in that car. The car then comes closer to one of the camera angles in front of the house where the cameras are monitored. Now you have a much better view of the victim's car, and there's no dispute that that is the victim's car that we see, a Lexus. As it approaches the house with the cameras, it starts to turn right up the street. So now you can see through, I believe it's the driver's window, it might even be the back window, but you can see two figures in the car. And one we know is the victim, that's her car. So when the officers told the defendant, we have you in the car before, that was their best evidence based on all the information they had, including, as Justice Cordy pointed out, his co-venturers who said he went there to meet with her, to get in the car, and to do this drug rip. So what happens is the car then goes out of camera sight. When it turns right onto Strathmore Road, it goes out of camera view. It then comes back onto Fairfax Road where the car parks. The problem is it's now just slightly beyond the angle of the cameras, so you don't see the victim's car at that point, where it's eventually found after the crime. While the cameras are still running, another car enters the view, and that's the witness, Sarah Ventura. She has a red sports car, and she parks to the house, to the right of the house with the cameras. She now gets out, and she testified at trial that when she gets out, she hears something that causes her to look in the direction of where the victim's car was. She heard a woman screaming, and she starts to walk. I believe she said she hears the gunshot. She keeps walking, and now she hears someone running. She turns, she sees, in her description, when she testified at trial, a 16 to 17-year-old black male between 5'5" and 5'6", wearing dark clothes, jeans, short black hair, running along Fairfax Road. Another gentleman had heard the gunshot, looked out the window. He too saw a black male. He didn't give a description as to the physical, but just a black male, short hair, and dark clothes running from the scene. So when the police, they knew all this at the time they interviewed Mr. Smith, and that was the basis for their interrogation.
But they also did say that they had his fingerprints, that they had his DNA, and they didn't.
That is true. And
it wasn't just on his glasses. I mean, they were basically saying, you know, the facts are the facts. Police officers don't lie. Don't put fingerprints inside cars. Don't put DNA on cars. I mean, they brought in, not just Tarquini was saying, and his other partner, but they brought in the town at one point to emphasize that they could prove he was in the victim's vehicle, and they just wanted him to explain what happened while he was in it. And there was an awful lot of that was based on stuff that just simply was not available to the police officers at the time, and they knew it.
I wouldn't agree that, as the motion judge found, there was more that they said that was true.
The motion judge found on the same videotape that we're watching. So we don't credit what the motion judge found.
Correct. In terms of what Tacchini said, who was the lead investigator, he made it clear at the beginning, and he did this at the motion to suppress, he said to the suspect, we have physical evidence in the car. He didn't say it was yours.
But that didn't stay that vague.
Right.
They basically nailed it to him. We had a view. We know you were there. We've got prints. We've got DNA. We know it was you. It wasn't as vague as when Tarquini started.
Right. I still believe in the Commonwealth's position, looking at that interrogation, The defendant was calm. He was listening to the police. He was offering, even when he mostly was frustrated with the police because they didn't believe him. And I think it's also important to note that he repeatedly said, "You don't believe me. What are we going to do about this?" And this is all before.
Yeah, he basically stopped talking for about, for 10 or 15 minutes before he invoked his right to silence, because the police officers said to him, "I don't want you to say you didn't shoot the victim anymore, because now you're getting to be insulting. Now we're going to work on the respect. Don't look at me and tell me that I don't know what I'm talking about." And then after that, the defendant really didn't speak so much.
Oh, the defendant did.
Not until after he had invoked his "I'm done." And then after that, for 5 minutes, 4 minutes, it's the police officer who does all the talking. And then is when he starts to spill the beans.
My notes reflect on the viewing of the interrogation is before he invoked, he had said repeatedly, "I've explained my side of the story. You're not believing me. You're not trying to work with me." And the detective saying, "Well, what do you mean we're not working with you? You don't believe me." And at some point, the defendant said, and I believe this is a minute or two before he allegedly invoked, is, "You're disrespecting me, saying I'm lying. You're trying to figure out things and just saying I did it." So
But had he said anything at
he
that point?
hadn't said anything at that point.
So why does that go to, what does that go to?
Well, that goes to, number one, in the totality of the circumstances, his will was not overborne by these two pieces of false evidence. But more importantly, when we get to the next topic, is whether he allegedly invoked. At this point, he's kind of going back and forth with the police about, you're accusing me of lying. I'm not lying. You're not working with me.
And they tell him to stop, don't disrespect us by saying that, so he basically clams up.
He didn't clam up at that point.
Oh, yeah, I think he did.
No, I don't believe he did. When he eventually says, "I'm done," and I think I heard my brother say he doesn't take exception to when Tacchini, who seemed kind of surprised, and says, "You're done with what?" It just was kind of out of the blue. And he said, "I'm done talking." In a post-waiver circumstances such as this, the courts have said it's good police practice when there's some ambiguity, which in this case, clearly there was ambiguity.
One question.
He asked the one question, which I would suggest is similar to the question that was asked in Clark, which was, I don't have it. But he asked the one question, "You don't want to talk anymore?" A yes or no question. The defendant answered, "No, because you don't believe me."
And then Tarquini says, "We already tried to explain that to you, Donovan. It's not believing. It's what we know, what the facts are." And
Donovan kept talking, and
and at that point, for 3 or 4 more minutes, it's the police officer who continues to talk, not Donovan.
Donovan does keep talking. He says, I understand. It's not that we don't believe you. We have this evidence. We have what the evidence shows."
Well, I think we're listening to a different videotape.
I'm 99% sure that Donovan keeps talking and says, "I understand. It's what the evidence shows." He
gave
talking.
responses to questions by the officers.
I'm sorry?
The officers kept asking questions.
Substantive question.
Only once the detective reasonably was assured that he did not invoke his right.
How was
to
he
silence.
reasonably assured that he didn't invoke his right? I don't
Because
understand.
he
it.
said, "Because you don't believe me." He didn't say,
that
"I'm
didn't
done
make-
talking," and he kept talking after the court have said, "You can consider what a
He
reasonable
kept
detective."
talking after about 4 minutes, after the police were continuing to question. Then he went on to talk. There's about 4 minutes where it's Tarquini who's talking.
He continued talking right when he said, "No, because you don't believe me." They start talking about it at the same time, so it's a little hard to probably understand what either one is saying. But the best I could understand, I think I put it in my brief, is he said, I understand. At some point,
That's what,
right?
that's what the defendant's saying, I understand. Meanwhile, it's Tarquini continues to say it's not a matter of what he believed, but what the evidence showed, that he knew from the defendant's body language that he was lying, that the defendant should lighten the load, get a little bit off yourself by telling police what happened inside the victim. That's what's happening for the next 3 or 4 minutes.
Well, in the totality of the circumstances, looking at what the defendant did post-waiver, he's been talking to the police for 20 minutes, expressing his denial of all these things, saying you're accusing me of lying, you're accusing me of lying, getting more frustrated. So when this issue came up and Detective Tarquini followed proper police protocol and attempted to clarify this ambiguity, I think we can look at what he said. He didn't just say no. He said no because you don't believe me, and then he kept talking. And
Yeah,
and
if
in
we can
cases
go
such-
back to that, I mean, I think from what I've just heard you say, certainly it sounds as if you agree that when Tarquini said you don't want to talk anymore, if the defendant had just said no, period, that would have been an invocation.
If the defendant did nothing said
Right,
nothing,
well,
did
I
nothing
understand.
after that,
If he had just said no,
Right.
you agree it's an invocation. So it's because he went on to say no, because you guys really don't believe it, that you say that distinguishes this from an invocation.
Absolutely.
And what is it about that sentence which you say, are you saying it makes it conditional?
Well, I'm saying that in the post-waiver context, in order for an officer to determine whether the defendant's intent was to invoke or another intent, he follows proper recommended practice by the courts and asks a clarifying question.
Right,
He
right. I
has
think
to be able to-
No one
it would-
disputes that, but I
So-
mean, but the question is whether it was an unambiguous invocation, and I gather what you're saying is that because you guys really don't believe it, makes it ambiguous.
Ambiguous, but also because the defendant, and I know Justice Lang doesn't agree with me on this, but I'm most confident that the interview shows the defendant keeps talking after he uttered that. Yes,
You mean
Detective Car-
without another question? Do you mean
Well,
because you guys don't believe me, da-da-da-da-da? Or were there some more questions in between?
There weren't really questions. There was Detective Tarquini saying, it's not that we don't believe you, and he starts to try to explain why, and at that time, the defendant is now saying, I understand, it's what the evidence shows, it's what we have, and they're kind of talking at the same time, but they keep talking. And also, I think for about a few minutes after this alleged invocation, the defendant says, you guys can question me all you want. I didn't shoot her. And he maintains that, of course, throughout the rest of the interview. And again, I think the courts can look at in the totality of the circumstances. You can't look at this in
But, I
isolation.
mean, putting aside the voluntariness, let's put that aside, because that's a separate issue from the
Right.
invocation. I know we have cases in which the person has said no and then went on to keep talking, and the finding was, well, it's ambiguous because the person kept on talking. If the person really meant no, he wouldn't have kept on talking.
Like Santos.
But do you have that here? Do you have, I mean, he says no because you guys really don't believe it, which is essentially, which seems to be, this is the reason I said no. It's an explanation for the no. Do you have a case in which the person went on to speak afterwards so that the appropriate inference is to say, well, no did not really mean no?
I can, Commonwealth versus Westmoreland, which I have in my case, 388 Mass. 269, a 1983 case. It's a post-waiver context. This is one where they arrested the defendant for attacking the victim, who was the mother of his child. He didn't know that the victim had died when, after he invoked, after he waived his Miranda, he said, I'm not making any statement knowing I'm being held for this alleged murder. But then followed that with, I did not contribute to what is alleged. And in that case, the court said that his invocation was not intended as an assertion of his right to silence because his conduct in saying, "I didn't contribute to what is alleged," belies his contention that he was exercising his right to cut off questioning. So that case, and I believe Commonwealth versus Bradshaw is another one where the defendant, and again, post-waiver context, I think, in this case, as opposed to Hearns, where even though it was post-waiver, he said he invoked mere moments after he waived Miranda. In this case, it's several minutes after he invoked
That
the
matter?
waiver. It does matter, Your
Why?
Honor. Because
But you've said he's gotten a Miranda warning that says he can stop talking at any time.
right, but as the court has said in Commonwealth v. Clark, when it's a post-waiver situation, a reasonable police officer faced with ambiguity can ask
Well, there's a real
clarifying-
question here, whether there was anything ambiguous about saying, "I'm done," and then he gets asked, "You're done?"
Well-
And he says, "I'm done talking."
In two cases, Commonwealth versus Howard, 469 Mass. 721, in Hearns that we've discussed, in both those cases, the courts had said, if only the police had asked a clarifying question as they're permitted, then maybe we could figure out whether the defendant had invoked or not. But in those cases, the police didn't ask the clarifying question, and they just kept on talking and seemed to elicit some incriminating statements. And that's why this case is distinguishable from those, because here the police exercised the proper police protocol with some ambiguity, followed up with a simple, direct question, which is, again, similar to what was asked in Clark when he asked, "So you don't want to speak?"
And I take it, I mean, it's apparent on its face that this interview took place in 2010, long before Howard, Clark, Bay, and any of those cases that have sort of amplified what this means post-waiver.
That's correct.
Just a couple of quick questions. You talked about the video. What you didn't say, and what I read from your brief, is the video also, right after the shot, captured an individual fitting the description of the person who drove up there, fleeing from the scene. So
Correct.
that's also in the video, not just the person getting in the car, then the shot, fleeing from the scene.
Correct, Your Honor. Thank you for pointing that out. You brought up another point as you were describing all the evidence that the Commonwealth had from the joint ventures. The one additional piece I'd add is that when the defendant came back to the apartment after the shooting, he went and said to Argo and Madison, I shot her. And I think
The police had all that. And one last thing, what happened to Mr. Young? There were the three co-conspirators, or three of the co-conspirators testified.
yes,
What happened to Mr. Young? He was the fourth.
he ended up playing out.
Okay.
Can I ask a question about the guns? The gun that was supposedly given to the defendant by, I forget who, but that was supposed to have been used to shoot.
Yes.
That was never recovered.
Correct.
Did the victim have a gun in the car?
As far as, no, I think the answer is no.
Nothing was recovered by way of a gun.
Right. The only reason there was a question of a gun was because when they were making the plan to target her, there was some indication that her boyfriend may be with her and he had a gun, or possibly he could have given his gun to her. So that's why they decided to give the defendant the gun, because there may be a gun in the car, but.
So there was no gun found at all in connection with this crime?
Correct.
Correct. That was taken by the defendant's brother and
Right.
hidden in their apartment.
Never found.
Yeah,
Never
So the
found.
defendant's brother did plead guilty here.
Yes.
So when the police said, we have your brother, they actually did have his brother.
They did.
With respect to was there ballistic evidence about what kind of a gun?
There
Was
was
used-
ballistic about the shell casings in the type of gun.
Yeah.
And it was consistent with the description of the gun that the co-venturers had given the defendant and the ammunition.
And there was
themselves.
description by them of the gun that they had given?
Correct.
Okay, and that was consistent with the ballistic evidence?
Right.
Okay.
Thank you.
No further questions. Thank you, Your Honor.